We'll get started here. Thank you, everybody. It's good to see a lot of new faces for this session. So we all just, some of us just came out of our Women in Innovation and Technology programming for the day. And we're transitioning to a new program that OTM has called Office Hours. Normally they're hosted in our office, which is down at 4240 Duncan. In the Cortex district with the big @ sign on it. We host these once a month on the third Thursday. Is that a true statement? Second Thursday? I knew Thursday. And we have lots of different topics, anywhere from how do you scale a medical device and get funding? How do you think about therapeutics, different opportunities and programs around startups and licensing? And today I'm excited to bring you a conversation around licensing technology into university startups from a national perspective. So we took advantage of having some of our panelists here for our Women in Innovation Symposium and thought that we would do something a little bit broader for the community for one of our office hours. So I'm going to introduce Lena Prabhu, who's our moderator. She's our Director of Licensing and Business Development. She's been with WashU for 15 years, and we've worked very collaboratively together throughout that time period. So she's going to be your moderator and introduce the panel. Thank you all for being here.
Thank you, Nicole. I'm kind of delighted to moderate this very engaging Office Hours series. So if you're involved in a startup or wanting to form a startup and anticipate negotiating a license with your tech transfer, this is just the session tailor-made for you. We'll delve into emerging trends. What are the changes in landscape? What constitutes a productive negotiation with your tech transfer? How to foster a very productive engagement? And before we dive into introductions, I would encourage each one of you to ask questions. We'll leave about 5 or 10 minutes at the end of this session for Q&A, but do not hesitate to ask questions to our panel members as we move on with this program. With that, I'd like to invite our distinguished panel members to introduce themselves. Katharine, can we go with you?
Hi, I'm Kathy Ku. I'm let's see, why was I invited? I have many perspectives. So I'm a WashU alum. I grew up in St. Louis, but I worked in the tech transfer office. I was the director of the tech transfer office at Stanford University for 27 years. I worked in tech transfer for 40 years. I retired and thought I was going to go travel. And then this law firm in Silicon Valley that's headquartered in Silicon Valley, Wilson Sonsini, asked me to join them. I'm not a lawyer, so that's also odd. But what I do is help startup companies take licenses from universities from all over the country. So I've been able to get a perspective on, one, the startup side, but also how different universities interact.
Todd Sherer.
Yeah, hi, everybody. Todd Sherer. And it's clear to me why I am here, and that is to be the token male on the panel. I do want to thank Nicole, wherever she went, for inviting me, because I have not been as familiar with WashU as I wanted to be, and I've really been looking forward to an opportunity to visit campus, so it's great to be here. The other real added bonus, though, is that these two women have been colleagues of mine that I've respected and admired for 3 decades. So to sit between them up here at a panel like this brings me great joy. It truly does. So I was trained as a scientist. I was interviewing for postdocs, and a licensing position came open in the tech transfer office, which I knew about because I'd been interning in as a grad student, starving grad student. I did anything for an extra buck. And I made a gut-wrenching decision to go into tech transfer. And the only reason I did is because I noticed it put a smile on my face when I thought about what I might be doing. It was 1990. It was a decade of the brain. I was doing research in the brain. And I thought, wow, I'm in the sweet spot. But we were hitting a real challenging cycle of federal funding. And I thought, boy, do I really want to be locked in a room writing grants when it's going to get tougher and the pay lines are going to go up or down, I'm sorry. And is that really what I want to do, as opposed to getting to work with as many researchers as possible and being exposed to cutting edge research and cutting deals and doing cool things like that, getting patents. So that was 34 years ago, and I still have a smile on my face. I still believe I've got the best job on campus. I love tech transfer. I've been doing it for the last 20 years at Emory University, but I hail from the Pacific Northwest originally. And previously I was in tech transfer at Washington State University, Oregon Health and Science University, then the University of Oregon, and back to Oregon Health and Science University before I came to Emory.
Thank you, Todd. Kirsten Leute. Did I say it correctly?
Yes, you did. You did great. Yeah, so I'm Kirsten Leute. I'm a partner at Osage University Partners. We're a venture capital firm that invests in startups out of academic institutions. I started OUP 8.5 years ago. I never thought I was going to leave tech transfer, honestly. I did work in tech transfer for almost 2 decades before that, mostly at Stanford, under Kathy. And I also worked with under Todd at Autumn. So like this is a wonderful deal for me too, because these are 2 people that I've worked with for a long time. And because for the same reason that Todd actually just mentioned, I loved doing tech transfer. It was so perfect for me because I got to work with an amazing group of researchers at Stanford University. And then I got to work with all these companies, et cetera. It was just so much fun. But I got this job to work at a venture capital firm where I got to work with 100 universities and what they were doing with regards to their startup companies. And I thought, well, that's really interesting. And I've loved that as well. So I've been very fortunate in my career to have had 2 main parts of my career and loved both of them. So I'm happy to talk about that, but we're really here to talk about, I think, the licensing process and somewhat the startup process as well.
So thank you. So let's get started then. In terms of evolution of university startup activity, how has the landscape of university startup licensing changed? What are the factors? What are the key factors that have impacted it? And do you see any emerging trends?
I can start since as for the longest. In the olden days, we didn't necessarily license startups, so we didn't realize that that was probably the best outlet. At Stanford, we just make a few calls, see if anybody was interested, and if somebody was interested, we grant them a license. But we found it really difficult to get existing companies to be interested in such early stage technologies. And the classic story that I tell all the time is that we had an invention that was a search engine and nobody wanted it. We marketed it to everybody. Nobody saw any value except these 2 kids. So we gave them a license. They made Google what it is. But it was that kind of story where we realized that a lot of times it's the passion of the inventors that makes it happen. And I think universities nowadays all realize that they're trying to create entrepreneurial environments and encourage startups.
Todd?
Yeah, I guess so many different ways you could answer that. I'll try to narrow it down. One of the ways I think is changed is that we understand that there are real consequences associated with our license agreements. If you've been in tech transfer long enough, you'll eventually go through litigation or arbitration or mediation or all 3. And you realize that what's in that contract really matters, even though everybody says, let's just get it done quickly. It's taken too long. We had an arbitration that we lost over a $20 billion a year drug that started over a comma. It's not how it got settled, but that's where it started, was over a comma. The other thing I think has changed is what Kathy was referring to, the amount of resources that are available for faculty-driven startups these days compared to what there used to be. They are the times of plenty in that regard. I've got more programs that I can introduce faculty to than they have time to check into.
Thank you, Todd.
Yeah. I mean, I don't think a venture capital firm like ours, where we're, looking solely at opportunities out of academic institutions, could have existed 25 years ago. But, we started really around 2010 or so. And it's been terrific to see the growth in startups. And the resources that, both Kathy and Todd have mentioned have really helped promulgate that. It is something that researchers on campus, instead of having to try to find someone, to help them. They have much more of a plethora of places to go to be able to assist them with that. And another thing that I was going to mention too is that another thing that I've seen change is that the possibilities for grad students and postdocs to be able to pursue these entrepreneurial activities or pursue actually a whole host of different types of careers that just didn't used to be so much the possibility. It was like, okay, you can go in academia or you can go into, you know, large business. Or you could go to a research lab somewhere. Now it's just, there's so many possibilities that are open to them. The research institutions with the resources that they have allow the opportunities and the technologies to stay within the institution longer, be able to develop them further based beyond to kind of maybe the very basic research that they used to have, and really adds value to these opportunities that could go into a startup company or a larger company, et cetera. Or kill it, which is also something we talked about earlier. It's okay to kill it. Like it's fine if you end up discovering that you can no longer do this. And I'm going to mention one more thing. Sorry. The other thing I think that the institutions are starting to do more too is one of the major things that happens on the life sciences side is when an opportunity is taken out into a startup is they can't reproduce the research. And more and more institutions now are doing that in-house to say, okay, is there really a there for us to be able to pursue further as well? So it's changed a lot.
I know. That brings up the next question. Let's say I am a startup co-founder and I want to license a technology from a university. When is the right time I should approach? What should I be thinking about? And what do you feel are the major challenges that startups are finding as they go through that process?
Well, maybe you can talk about when they should contact you and I can.
Yeah, I would say they should contact us early for a number of reasons. One is it's helpful for the tech transfer office to know we might be heading the startup route. It sometimes disappoints my licensing team when I don't say, you know what, even though that faculty member wants to start it up, let's force it this path with the established company because they've got the resources, and this faculty member hasn't thought about what the company is going to even look like yet. And in my experience, pulling a baby out of the hands of a faculty inventor to force it someplace is never going to be, it's just not worth it. So a faculty member by definition wants to start a company up, then that's something we really try hard to work with. I don't mean that we don't try to say, hey, here are the problems and the challenges and the opportunities that come along with that. It's just that I wouldn't pull it away from them and force it down. So we want to know that early on in managing it. I want to help them understand that they may be responsible for things like patent expenses. And so we would begin that conversation with them. And then there's always the age-old problem of you have to start early because it's the only way you can find that next level of funding that will help you do the applied type research versus can you wait until there's resources and money in the company so that you can do things right.
So I always tell the clients to tell the university early on, just for the sake of the university needs to know. And then they'll pay more attention to the patent and they'll really care about it a little bit more because they know that there'll be eventual outlet. But the entrepreneur needs to think about really what do they want to do with this company and how are they going to build a business around that idea. And I always say that you need, and rightly so, the university wants some sort of plan, a development plan. It doesn't have to be this full-blown 50, 100-page thing. It's 2 or 3 pages, but you need to think about the timeline, how long is it going to take you, and how much money is it going to take you to develop whatever you're trying to develop. How are you going to put a team together? Do you have a team now? Do you have people to help you? You need to think about that. And then the milestones. And the university wants you to think about it, and so does the investor. The investors need to be able to feel like you've thought these through, and I think it takes a much longer time to think these things through than the uninitiated entrepreneur thinks.
Kirsten, do you want to add to it?
No, I think they've covered me.
In terms of faculty co-founders, how do you feel their roles have evolved over this time period? And in what way can they add value to the discussions that are happening between the startup and the university tech transfer? Should they, shouldn't they? That's the question.
You're the university person.
It was, it's one of the things I would have said changed. So when we first started focusing on startups, what decade was that? Maybe the late nineties or
Mhm.
somewhere in there. The theory was that, well, gee, are you going to start the company? Are you going to leave the university and run it? We used to kind of almost really think that's the way it needed to be. Now we actually have to tell the leadership and others that we want to retain our faculty. Plus, we recognize that generally speaking, they just don't have the right background to be a successful CEO of a startup company, although I have seen a few exceptions to that rule. And so we want to, and so we want them to participate in as many of the programs as they can that will give them sort of the insight and stuff into that. I lost my train of thought, but so I'll stop there.
I can add that at Stanford, you're not allowed to have a managerial title. So you can't be CEO and be at the university. You can take a leave of absence for a year and then a second year if you get permission. But generally, you can be a founder, and that's different than being a line manager. So the university really cares about separating responsibilities. And at Stanford, we had a rule that you couldn't, the founder couldn't negotiate with the office. And I think that's a fair ask, because there's a conflict. You got two hats on when you have a company hat and a faculty hat. And the reality is the faculty at the very beginning wants the tech transfer office to be really easy on the company. You know, just don't charge them very much. The reality with many, many companies is that there's a falling out. Well, there's a time when parties are going to separate ways and just faculty be less involved. And then they come back and say, well, why didn't you ask for more? So the tech transfer office really needs to be pretty objective about what they're asking for and what they require.
I was going to add, to the best of my knowledge, we're the only university in the country that has a set of IRS guidelines that actually prevent us from negotiating directly with faculty. And on top of that, we are required to get an external fair market value assessment of a startup in which our faculty member hold founder shares. It started out of a proactive audit on campus for a whole different reason, but this was one of the results of it. Because of the concern that if we give a sweetheart deal to a faculty-driven startup, that there could be a private inurement consideration. And in order to make sure that there's not a private inurement thing, we didn't give you a sweetheart deal, we get the external fair market value assessment. And so that's our mandate, is to get fair market value for our technology, including startup technology.
That's a follow-up question. How much does that assessment, third-party assessment, cost?
Fortunately, we found a law firm that we can do them with, and we don't do a lot of business with them, but we have repeat business with them. So it tends to be in the $3,000 to $5,000 range. Yeah, that's pretty reasonable.
Before we wander off too far, I just want to ask too for clarification, since the conversation has been directed about faculty. What about graduate students or recent graduates of PhD programs? Do they have the same barring for negotiation? How do you look at them when it comes to a team?
So it depends on whether they're still at the institution, first of all. If they're still an employee of the institution, that does make a difference rather than them having fully left the institution. But they have to still understand that you're representing them. Because you're representing their IP, and they're going to have a financial benefit from that IP. And so they just need to take that into consideration. If they're the ones negotiating, they're negotiating on behalf of the company, but the university is also negotiating on behalf of them, because it puts the people into a very kind of bizarre position. Plus, they don't necessarily have the expertise. If they haven't actually negotiated a license before and negotiated the terms, really, there's probably a better expert to be able to do that for them than themselves. Still terrific to get input from other people about, like what is fair market value, but just FYI, yes, I did used to work in the tech transfer office, but I've worked with a ton of tech transfer offices now, and no one's trying to gouge a startup company, but they do want something that's going to be a fair deal for the institution down the line that, if the startup does well, the institution potentially could do well as well. But then it's your question. I don't know if you guys have different responses.
Yeah, I would say we would look at postdocs and graduate students if they're still at the university similarly to the way we would faculty. At Emory, they are allowed to hang their shingle out as being the CEO for some period of time. Eventually that has to change. But the conflict of interest issue would still have to be managed. And we do know behind the scenes, I mean, at the end of the day, if you've hired somebody to be a negotiator, we know who they're going back and having a conversation with.
Right.
But it can still be helpful to be sitting there in the room to make sure that it doesn't get personal. That's the other thing that I think is difficult for our inventors, whether of whatever category it is. It quickly gets personal and they're not accustomed to thinking that everything is negotiable. If you're in a tech transfer office, everything is negotiable, and we disagree with each other all the time, and it's just the normal course of business. I've seen our inventors take it personally too many times. Plus, it is part of it is an appearances thing too. Again, I would argue from Emory's perspective, we need to demonstrate that this was a third-party negotiation, and if we're negotiating with ourselves because you're our employee,
Yeah.
that just doesn't have the same visibility.
And this would be
perception.
similar to the WashU perspective. We do not engage or negotiate directly with faculty members, postdocs, or graduate students. You are free to work for the startup, but we don't directly negotiate with you. Sure.
How does the faculty member or the postdoc find someone who's willing to negotiate? And it's like they can't start, it's a double-edged sword. They can't start a company, but yet they need to have someone at the company to negotiate on their behalf. Like, how do they do that? And if the university is like matchmaking, that also feels weird from a conflict of interest too.
So talent is the biggest problem with startups. It is not funding, it is talent. At the same time, so going to the tech transfer offices, I know at WashU, you do have New Ventures associated folks who are helping out. They actually are a good source of meeting people who may be possible business partners. Honestly, it is mostly about networking and finding a person who's going to be the right partner for you. It shouldn't be your neighbor down the street or your best friend necessarily, unless for some reason they have that domain, et cetera, expertise that's, really fits in with yours. We were talking about this in our earlier session too, but a lot of it is having really good conversations and figuring out who are those right business partners for you. Like I have friends, we talk all the time, like we would love to start a business together, but I also know that probably wouldn't be so great for our friendship necessarily. So you just have to be very cognizant of that. We always like to say that who you end up going into business with, like that's the second most important relationship decision in your life. The first one's obviously your partner in life, but the second one is who you go into business with. Because it is that critical and you're going to spend so much time with those particular people. So how to find those people, biggest problem, networking, using the New Ventures resources. I'm sure other people here have other suggestions of how to find them.
WashU has a list. Yeah, go ahead.
Oh, I mean, you can always hire an attorney. Since I
Yeah,
represent an
right.
attorney.
That's what I was gonna say, yep.
But, and a lot of firms give a deferral for startups. They'll not charge you until you raise money, things like that. And you need to control the lawyer though, because the lawyer can negotiate forever. And then they're not really trying to run up a bill. I would say now being in the law firm, they make their money as the transactions, as the financing happens, as the company grows, et cetera, et cetera. It's not the license, but that's the start of the legal advisory relationship that a company might have. So you can go to an attorney.
Yeah, I was gonna say that's the most common thing for our startups, if they don't have a business founder yet, is to use a lawyer partner to negotiate for them. As far as making the match though, that you said, and picking the partnership and that to me doesn't feel like it is awkward at all. And the reason I say that is because at the end of the day, the startup company makes that decision. We can make all the introductions we want, but we do not incorporate your business. We don't run your business. We don't make your business decisions. So it's your decision at the end of the day to pick the person we might introduce you to. We don't pick that person and put them in place for you.
I will say that, I'm just gonna mention really quickly that, you know, like, if you're looking, you know, for, you know, how to negotiate that agreement, et cetera, like, when I see that kind of more from our investment perspective, I do like to see that those scientific co-founders, business people that they brought in help them with that, because they aren't necessarily business experts, plus the attorney side. Like, to me, that's kind of an ideal, right? And I would love, you know, like, if there is an early stage investor that's also been inviting them that I actually really respect, boy, that's just like gold right there. So.
Yeah. And from a WashU perspective, we don't match make, but we do give you a list of candidate law firms that work in that space, and then it would be up to you. So you would have to do diligence in terms of, you know, talking to the attorneys and finding out what their billing is. And it's always, I think someone mentioned it, it's prudent to not only have legal representation, but also have the business focus. So it's a much more balanced conversation. In terms of deal terms and current trends, could you talk about a case scenario where the expectations from the startup aligned very well and things went really great, and it was a very productive conversation? What are the elements of that engagement look like? Any kind of example that you can think of?
You mean the elements of what makes the negotiation work well?
Yeah.
I would say transparency. We almost always have a good experience with our business partner when they're incredibly transparent about what it is that they need and what they're trying to do. Maybe that's just part of who I am because I wear my heart on my sleeve, so I appreciate that in other people. But I think from a negotiation perspective, what doesn't work so well for us is when you can tell somebody's sitting across the table and they're going to withhold information because, hey, this is my information. The less I share with you, the better. I think those are negotiations that get more testy for us.
I agree, because, you know, both sides need to develop a relationship of trust, because this is, and I always tell our clients, the startups, this is a long-term relationship. This is a 20-year relationship, possibly, and possibly longer. And so there are going to be unforeseen circumstances through this journey together, and you need to be able to trust each other. And so I think the transparency is really important, forthright coming forward. I always tell our startups, if you're not gonna make a diligence milestone, you know, let the tech transfer office know ahead of time. Because the more you have the tech transfer office being sympathetic with the company and understanding what's going on, the better the relationship is gonna be. And then the more they'll work with you.
I would say that for me, when I was in tech transfer, like, there were certain attorneys I knew I worked really well with just because I've worked with them so many times. So, like, Vern was one of them. And I just knew that we'd get a deal done. Like, I knew that we get into it. We knew how each other worked, and we get done quickly, unless there was something going on the company end.
Right.
So that was helpful. It was that we had those relationships already. One of my favorite licensees ever, you know, and the company I don't think it ended up working out fully, but we would have lunch quarterly. And they just catch me up. Here's what's going on with the company. So, like, there was already an obligation that they had to send us yearly progress reports, but no, we actually would have lunch every quarter. And so anytime they needed to make an amendment, it was so easy for us because I already knew what was happening with the company. And so it's not just about, like, when you're entering into this license agreement, you can't just say, okay, I'm going to get this license agreement done and out of the way, and then I'm not going to have to think about this anymore. It is a long-term relationship that you're trying to enter into with the institution. And just view it as that, like, for any long-term relationship, you're going to try to do things to make it stable.
And it's I was about to say that sometimes the negotiations don't go as well for us, are ones where the startup's gone out to hire an attorney to come in and negotiate. Wilson Sassini solved that problem by having someone like Kathy on board to say, okay, how is it that this should work? If you've just got your attorney that is there to represent your best interest, which is what they're paid to do, right? But at the end of the day, they're not responsible for the business, so to speak, and are willing to have the compromise and have the open, transparent kind of conversation. Sometimes that doesn't come along with just hiring an attorney to be a negotiator on behalf of the startup. Because it really takes the commitment to building this thing together. Like Kathy said, I mean, on day one, all we have is risk. The only thing we can do to try to compensate for that is build as much trust as we can. Because we're gonna have to, if we can't trust each other, then we're gonna have a difficult time eliminating all that risk, so.
And the reality is both the university and the company want to be successful. Really, both you're aligned that way. So, maintaining that relationship, the good one is really important. And the other thing, and again, because I work at a law firm, lawyers are trained to be risk averse, but it's a business decision whether you want to take that risk or not. And so the business should decide how this relationship is going to be and what the license agreement will say.
Can we stop, pause for a minute? Any questions from the audience?
I was, or I am a little bit curious about terms. And how much variation there is in terms, so you're gonna be royalty rates and other kinds of terms in these licensing agreements. And, can you comment on some of that hard stuff? Or is
When a client, a startup gets a term sheet, I say the two things to look at. You're always going to have an equity component, usually with a startup. And then you're going to have the earned royalties, because when you sell a product, then that's what you're going to pay the university. All the other stuff I feel is semi less relevant. And even the university, even if it's a high milestone payment, for example, it's going to be dwarfed by the royalties if the company is successful. So everybody wants a company to be successful. You'd like the equity to be worth something. So those are the two main economic things that one would focus on.
Yeah, I mean, the typical ways we get paid, and Lou Burnham used to say this, how do universities like to be paid under a license? Well, every way possible. We want reimbursement of patents, and that could be sunk costs as well as ongoing costs. We want an upfront component, whether that's equity or cash. We want milestones. There could be things like maintenance fees, and then of course there's the royalty. I mean, those are the financial components typically in a license deal. They may not all be there in every single one, and certainly the equity and the upfront cash generally are not, although that can happen too. And then it's a matter of negotiating those. And while it seems like there are sort of a few standards that can be referred to, I mean, the 5% royalty has been thrown out over the years is sort of the magical target to shoot around. But there's an incredible amount of variation that goes into a license negotiation, a lot of things that impact that, which is why the transparent conversation makes sense. And if you can present a good argument to the university as to why your particular product and what you think your margins and stuff are, why they won't sustain this particular royalty rate or upfront fee or whatever, it goes a lot more than if we just have a conversation that says, I want it to be 1% and 5%.
Yeah, exactly.
Kirsten?
I can't comment too directly on this because we have a database of licenses, startup licenses from universities, and the financial information from all of those that is actually only accessible to our universities. However, we can provide that information in the universities, and they can provide the information verbally to you. But I can comment generally about it is that honestly, royalty rates don't vary that much. Everyone's kind of come to around the same conclusion on royalty rates. Equity, anti-dilution, kind of similar. Because people kind of know what's fair. And what we're trying to do is get to a fair deal that gets the startup company out the door, but also means that if the startup company does well down the line, the university can see some small part of that. And the whole reason that we're getting this part back, right, is to invest in further research. That's why the Bayh-Dole Act exists, is that universities potentially receive this remuneration back to be able to invest further in the research at the institutions. So it's not like lining their pockets. It's actually to help advance more of the further objectives that the research institution has. I had another point on that, but I totally.
One of us, we see that there is a little bit of a geographical difference.
There
The
is
coasts,
higher terms.
higher terms, yes, compared to the middle of the country. And again, to me, it's a matter of whether they have a very robust entrepreneurial ecosystem or not. If they feel like they can ask for a lot, they will. The Boston, Silicon Valley, they do. But if they're trying to build up an entrepreneurial ecosystem, they're really wanting to encourage the startups, and the terms will be quite reasonable.
And then, of course, they can vary a bit by sector too. I mean,
Yes.
the royalty rate that we get in a therapeutic deal is different than what we see in our medical devices. Just the starting points are even different, but
Yeah, or tech, there's software or something.
Right, software is totally different. Yeah.
Just to add to that, Todd, you mentioned there's some internal translational funding that the university has to put into various technologies. Does that really impact on the overarching deal terms that you expect that the university is putting in? Internal.
it can. And I'll explain why I would say it can. So if we've got a couple of translational funds that would provide somewhere between $500 and $200,000, probably the additional value that gets created with those is not going to be reflected in by the time we're done spending that fair market value for that technology. But Emory also has something called Drive. It's our own wholly owned biotech company is essentially what it is. And it's investing millions, in some cases, putting tens of millions of dollars additional, not tens of millions, but up to $10 million. And in that case, we are really expecting to see a step up in the valuation. And we're aiming to do more than that, more of that, I should say. We've just created a couple of new venture-like funds that'll be 100% within Emory, one in the therapeutic space and another one in the medical device space. So Emory wants to do more of that. We want to find a way to reduce risk, create value, and have that be reflected in the deal terms. Now, the challenge sometimes is getting those other people in those other offices across campus to understand that while their job was to fund it, my job is to get the return for the university. So back me up when the startup comes crying to you to say, hey, I don't want to pay this, can you go talk to that tech transfer office? And, I don't mean to say that gives me free reign to just ask whatever I want. Again, I still endeavor to find what fair market value is. I'd like to be at the upper end of the fair market value range as opposed to the lower end. And I understand that nobody will ever be on what's fair market, but at least that's the operating theory there. So we're hoping to do more of that. And carry the football farther and then have our value reflected.
Yeah, I didn't mention that at the beginning, but that is something that I have seen also changing at the universities, is that when I first moved over to OUP, everyone was telling me that they were going to start a venture fund, but very few were coming to fruition. The last couple of years has changed a lot, where a number of institutions now do have their own venture funds. They're usually small venture funds. They're usually looking to do that kind of pre-seed funding stage, but they're really trying to help those startup companies get off the ground more. So these are typically around $10 million funds. They're probably going to invest like initial seed round of 250 or so in the companies, maybe doing some follow-ons.
Catherine, you want to add to?
Oh, no, I think it's right.
Okay. Any other questions? Sure.
In terms of who's actually licensing the IP, what's the kind of general breakdown between like students who are doing it, like the search engine founders that you talked about, versus like big companies that are licensing versus like some serial CEO who's got 3 exits and is, just looking for a new hobby. Like what do you see with people who you're negotiating with?
First of all, I would say that about 30% of our deals are with startups, by number. If I had to try to break down who's typically doing them, and again, so the thing you have to remember about Emory is that 98% of our technology is in the life sciences space. we tend to see far fewer students, postdocs, whatever, slipping in as in the CEO role in those companies than you probably do in the tech world, where it's probably maybe exactly the opposite. But I wouldn't say there's none. I mean, we have examples of where we've got postdocs or grad students when they finish up, and they're going to be the ones that are going to go out and be the project manager, whatever I don't want to put with it, to run the company. So we are seeing that happen, but most of the time we're still dealing with the faculty member. If I understood your question.
You said 30% startups and then.
And of that 30%, probably 70% are faculty. They're being driven by faculty. That other 30% is maybe a miscellaneous combination of a grad student or a postdoc or somebody else.
And then the 70% is like.
The other 70% are to established companies.
Yeah.
Dr. Pan, you have a question?
So we just talked about this licensing as a long-term relationship. So could you share with us after this licensing agreement is done, after that, how this relationship?
You know, our longest time frame, and bear in mind, of course, most things are not successful, but from something, if our longest time frame of something that was disclosed to the office to the time it got FDA approval was 22 years. It was disclosed to the office in 92 and got FDA approval in 2014. That was for a therapeutic in the chronic hemophilia space, which is a very orphan indication. And so that was part of the reason that it took that long for that to happen. But tell me the other
So
part.
my question is after this.
Oh, yeah,
licensing
right.
agreement is
Yeah.
signed,
So it's kind of funny because I feel like when we got started in tech transfer that we were all about getting the deal done.
Yeah.
And we talked our universities into, my theory is we told our universities, we like to do this tech transfer stuff. And they said, I don't know. Okay, well, here's a budget. Okay, well, we're going to hire some people to negotiate licenses. And then we said, well, but we need a patent budget. So what we did is we really focused on getting deals done. And then as the profession started to mature, we started to realize we needed to manage our licenses post-license. And so now we've got more sophisticated approaches to doing that. And of course, to your point, and probably where you're asking the question, by the time it's all said and done, there's more effort that's going to go into that if the technology is successful. If it's not, then of course it can die and shortly after licensing and never require much more effort. But if it's going to be a successful technology for the product, we find that we're going to put a lot more effort into the post-license issues. And we've got people hired to do that. Now NIST has changed some of the obligations on utilization reporting and things like that, and US manufacturing. So we're putting more and more effort in our tech transfer offices into managing post-license issues. And again, that's where you can get it. I've been through arbitration, litigation, and mediation in the 20 years that I've been at Emory. So those are it's become much more sophisticated. But we're still by and large sort of offices that were built to go out and carry and kick all these balls down the field and try to get them across the goal line, meaning a license executed. That's probably still where 80% of our efforts.
So, I mean, one of the basic things is the license will require a report every year. And you're supposed to be diligently developing the technology. And so there will probably be milestones or diligence milestones that you need to meet. And invariably, I tell our clients to be very generous with yourselves as far as what you're going to do, but you usually don't make it. And usually you have to go back to the office and say, I'm sorry, but we ran into this challenge, we ran into that problem. Please change it. Or you're going to find an investor who doesn't like blah, 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 something. And you're going to have to go back and talk to the tech transfer office and say, this is a problem because somebody doesn't like it. That's going to invest in the company, and will you change it? So there's a lot of things that are unforeseen. You have no idea what it's going to be, that you have to go back and ask for a change.
which is the amendment.
Right. So we used to say, in a really good relationship, you amend every 2 years.
And eventually you may just have to restate the entire agreement because it
Yeah.
may have changed so much. And the thing is, you don't know what your business direction, like you think you know what your business direction is right now. But as you're building your business, as you're getting investment, as you're doing more research, you're doing market research, you're doing your internal research, your business is going to change. And the tech transfer office is gonna work with you on that, like, but it does, the agreement will likely have to be amended because your milestones are no longer applicable to the new business that you, that you have, or something else happens along the process. That's why Kathy said, give yourself as much leeway as possible on those milestones, but you are gonna be required to have milestones a certain amount of time. I remember when I was negotiating, agreements, I would actually usually try to get the company to only put in the first 5 years of milestones, and then we'd meet and agree upon the rest of the milestones, because I thought, if you try to give me 15 years worth of milestones, there's no way you're gonna hit the last 10 years of that, because your business just isn't gonna work like that. So that's why I said before, when that person would have lunch with me every quarter, it was wonderful, because I kind of knew ahead of time, I could anticipate what was going to happen. The other thing too is, like, once you start selling a product, then you have to start submitting royalty reports to the university as well. Sometimes they're going to be yearly, sometimes they'll be quarterly, kind of usually depends on the amount of those. So there's a ton of things. Oh, and then there's the patent prosecution, right? Like, we didn't even talk about patent prosecution. That's another whole thing that you're coordinating with the university on constantly. So there's just this, Todd said there's so much that is put into kind of this initial agreement getting done, but it really, the bulk of the work is beyond the agreement, because you're doing this wonderful business, but the IP is still owned by the university, and you've got this agreement with them.
I can think of many times over the years where we have amended an agreement to decrease the financial consideration. But in 3 decades, I can't think of one single time that the company came back and said, because of this, we think we need to increase the financial. One time.
Yeah, and that was always, and so it's funny because somehow universities get a lot of pushback on the financial terms they ask for, which again are never, like, in my experience, not really egregious. But the thing is that the university is never going to get more typically than they asked for at that beginning.
Yeah.
And
We
it's
might get
only going
less.
downhill. Yeah, right, exactly, if anything. Unless there's new IP added or something like that. Yeah,
That
sorry.
ties to my question is related to new IP or ongoing. And so for a startup to be successful, it's not just one IP, it could be a portfolio. And some of them are already approved, some in the process, some are to be developed. So how do you manage this kind of relationship? Like, I mean, maybe here's a chance to add to it, but I don't know what's the standard of practice.
Sure.
Yeah.
Happens on a very regular basis. Sometimes there's ongoing research at the university that they want to fold into it. Some universities kind of allow for provisions in their license agreement for that to happen. Some universities are very against that being a possibility. Sometimes there are in-between provisions that you can have. The thing is, right, like, it's very hard to make a definitive cut between what is happening at the university and what is happening at the startup. But as much as you can make that definitive cut is actually to the benefit of the startup company. It's just not always possible, and that's okay. The universities know how to deal with that. There is sometimes a sponsored research agreement, that's going back from the company to the university as well. That's going to create another host of IP issues. The other thing that the startups, people who are associated with this all know is that, as you are doing the company, you're going to be creating your own IP, and you're going to rely even more heavily as things go along on that own IP that you're developing as well, and may become less reliant on the university IP. Maybe the university people don't want to hear this, but it just, that is how the natural order of things, and progression of things does work. But again, the tech transfer offices know how to deal with this, and will be able to, there's either going to be an amendment to the agreement adding on the new IP. It may include new financial obligations depending on that. Sometimes it may be subject matter that is already covered and that can be slotted into the license agreement. But again, you can't know ahead of time what is going to happen in the future. Just, you have to, again, trust your partner that you're working with, that it is going to work out for how you're going to handle that.
Did you specifically ask about improvements?
Yeah, there could be improvement, there could be modification.
One of the things I wanted to say about improvements is that's challenging for the university, and it's also challenging for the company, because they don't want to license something from us today and find out we discovered something better tomorrow. I get that. But here's the hard part. So it hasn't been discovered yet. How are we going to value it?
Right.
The company's got to anticipate that it might not be worth much of anything.
Mhm.
They can't afford to overpay for it. And the university has to anticipate it could be something really great. So how do we value that? And who's right and who's wrong in that? And so there's the problem with improvements. How do we price something that hasn't been created? How do you achieve fair market value for something that has yet to be invented? It's very difficult to come up with a win-win sort of value around something like that.
And who sponsored that? How is that different from the previous sponsorship? Who invented that? How is that different from the previous inventorship? How you can't, it does get very complicated.
Yeah, so probably like a new agreement will be in place.
Or an amendment or something like that, yeah.
Yeah, yeah.
Then related to the, for example, equity and royalty, right? If there's a already set certain like amount of equity and royalty, the new one will add on top of it, or like after negotiation.
Not always, not
Yeah.
always.
Yeah, it would be on case specific, so it's not like a one size fits all. And very often these are very modest terms because we are dealing with startups. So coming to that, unless there are any other questions, sure.
So just going off of that, not knowing the future, is it typical for, an initial license agreement to cover one patent family?
I would say it's very common for a license to cover more than one patent family, if there is more than one patent family. And there quite often is. As you know, we might have filed, because we have to file early, and now we're first to, we didn't used to be that. But we're first to invent country, so we try to file early, and we're trying to beat publications and things. So there can sometimes be 2 or 3 families of patents that exist. And also sometimes they're just distantly related, bundling IP is been a popular concept for a long time. And so trying to bundle it under the same license agreement. So it can be very common. But that doesn't, but usually research continues at the university. And if research continues at the university, then that creates the opportunity for new technologies and improvement type technologies to be invented as well.
Another trend that we've been seeing from the investor side is actually startup companies where the IP is across a lot more institutions. It used to be institutions and faculty members really kind of stuck within their little sphere. That is just not the case anymore. And so a lot of the startup companies that we invest in now have IP pulled from different institutions or is co-owned by institutions, which just makes everything more complex. It's totally workable. It's just more complex.
Well, we've all been tasked as universities to collaborate, right? People don't want to hear that you do your own work in your own silo. Legislators, everybody else wants to see faculty. And we just heard about it today in one of the panels in there of the collaboration between different departments and stuff. And collaborations between different institutions so you can bring that expertise together. And the rest of the university loves that. The tech transfer office, it isn't that we don't love it. It's just that you just complicated our lives. And by the way, you complicated the startup's life too, because now it's got 2, now there's 3 or 4 parties that are involved with it. But it's the way of the world. We got to collaborate. We want cross-disciplinary approaches to all these things.
Sure.
How often does an investor just purchase the IP, like with the startup? Like they don't license, they just say, I want to buy this and own it.
In the US, not.
Almost never.
You can't buy it from a US institution. US institutions don't assign IP.
We license it.
Yeah.
The only time that happens is if we elect not to pursue something, then under our IP policy, WashU IP policy, and that may vary from university to university. If we relinquish, that is the university relinquishes its ownership rights, then yes, we are bound by our IP policy to then offer it to you as an inventor or inventors.
But most of the time it has to go to the government first. So
Yeah.
it gets much more complicated.
And it's not a sale, so.
Yeah.
Yeah, it's not a sale.
Right. Yeah.
So it's totally different with industry, right? Because the inventors don't have any. In industry, like one of the things that's a real privilege, I don't actually know if in academia always appreciates this, is that so in industry, as an inventor, like you usually don't get anything out of your inventions, right? Like your company owns it and they can do whatever they want with it. And there's usually no remuneration back.
You just
to
get paid the higher salary.
You hopefully get paid a
Yeah.
higher salary, and then they said sometimes give you like oh, thank you, here's $1,000 for inventing something this year, or something like that. But it's very different in industry, so.
Other questions? But, oh yeah, okay, we have enough time. We have a few universities also coming up with custom startup licenses called express licenses. What are your thoughts on that?
From the startup side,
Yeah.
I'm not in general in favor of that. Because you gotta do the work now or you do it later, and it's more expensive later, because again, the express licenses always have to be renegotiated when you have investors, potential, lots of things happening. So I feel like it's worth putting in the time early to get it right, and then you can move forward.
Because some of these are non-negotiable as well, and there are a lot of qualifiers for that, so.
Well, and there's two different, my experience, there's two different types of express licenses, and 80% of them are a low-cost license. And my institution doesn't give low-cost licenses. I don't believe it's in our inventors' best interest for us to give a low-cost license. They might think so at the time the startup is being formed, but if that technology is successful, I bet too many back in my office saying, why didn't we ask for more?
Yeah.
The second thing I was going to say is it's always been a mystery to me. And after 34 years, I still can't figure out why there's so much focus on why there's such a strong negative opinion about the time it takes to negotiate an agreement. If you're going to start up a company, I guarantee you that negotiating a license agreement is not going to be the most difficult thing you will have done if you are successful. So this is a document that can live for decades. A comma that you place in that. We hired a history professor to be our expert witness in the arbitration to argue over where the comma was placed. That document matters a lot. But it's the first thing a startup has to do, and because it's the first thing they have to do, and it takes a lot of time, because we're not all as staffed as we would like to, everybody focuses, and there's so much negative attention. And by the way, I track the turnaround time on our companies, and companies aren't so fast either. But it's an incredibly important document, and that's, to Kathy's point too, that's the second reason that I love express licenses. If I were starting up my own company, I wouldn't want to hand a license agreement and say, I've got to agree to all the terms in this. I want to carefully consider them and make sure that I thought they worked for me. But they're popular because of the huge pressure the huge pressure to try to reduce the time it takes to get a contract negotiated. This document that you will live with for decades, everybody wants it to be done in a week.
In general, like, there are option agreements out there. Option agreements are, for those of you who don't know, an option agreement is usually a term limited ability to take the eventual exclusive license, but they're much shorter. They're usually very simple to execute. They can give you that runway to know whether you want to take that full license. And if you're getting pressure, let's say from a group of usually smaller investors or something to take a license, go for the option agreement. I do think that there are ways that express licenses can work well for institutions, but they really are going to be in specific industry areas or perhaps specific types of technologies. So a number of universities that have express licenses, they've targeted them towards those technologies, perhaps lend themselves towards a one-size-fits-all type of licensing. And the question is, like, do you think that your technology fits a one-size-fits-all? If you don't, then you shouldn't be doing an express license. You should be doing something that is custom towards what it is that you're doing.
Well, and if it truly is a low-cost license, so you've got the opportunity to take the lower cost, you can balance that against the risk that maybe the agreement doesn't meet your needs in all the other ways. And maybe it's worth doing that. But I'm not sure if you're an inventor, I'm not sure why you would think that a low-cost license is to your benefit. And maybe I'm too focused on the life sciences space, but I sit my inventors down all the time, and I can show them a spreadsheet of how much more money they're going to make off the royalty, then they'll make off their equity position at the start. So,
Oh, no, it's,
Um,
we have the data too. It's-
yeah,
we-
so they get so
Royalties,
locked
so
into
much
that,
more.
and that equity position, they're going to get as being a founder in the company. And they lose sight of how much revenue they can make through the license agreement, and yet it can be so difficult to make that point to them. And I've created spreadsheets so I could show them the numbers. Which is another reason why we don't negotiate. We like to negotiate with you, right? Because again, you're wearing your hat at the moment, and that is the
Right.
startup. I want this low-cost license. I've got to get it as low cost as I possibly can. The investors are telling me
Yeah.
that I'm gonna be more fundable if I do this. And you're not able to put the hat on that says, okay, what happens when this thing is successful? What happens when the royalties come rolling in the door? You know, they're inventors that have made hundreds of millions of dollars off of these things. And the difference between a 2% and a 4% royalty on something like a drug is hundreds of millions of dollars a year. Why would you want your tech transfer office to short you on that? Unless it's only because you can't get your license funded. It does have to be fundable. We all have to live with that.
I think we've run short on time. Any last burning questions that you want addressed? Sure.
So, could you share with us from early venture capital perspective in terms of you look at the licensing?
Yeah, honestly, we want to know the licenses in place, but we know that most licenses are fairly similar to each other, honestly. We honestly, this was actually really something that was illuminating to me when I joined a venture capital firm was when we're looking at the opportunity to invest in a company, the license and the IP associated with it is one very small part of what we're looking at. We care much more about the market and the science and the team and the expertise and what it is, how they think they're going to drive this forward based on the money that we're putting into the company than the license and the IP. So I think that it's so that's why it's important, but at the same time, it's not usually the thing that's stopping the deal going forward. It's everything else that's much more important about what we're looking at. So I hope that answers your question. There are cases certainly where investors have not gone in because they thought the license terms were too egregious, but those are very few and far between.
Okay, with that, I think we're going to conclude this session, but not before we express our sincere gratitude to Kathy, Todd, and Kirsten for taking time from your very busy schedule to be with us and share those pearls of wisdom. We greatly appreciate it. Let's give them a round of applause. And to you, the audience, thank you very much for coming here and joining us. We truly appreciate your participation.